This is a continuation of Chapter 7, where we're going to be talking more specifically about international law. In the next lecture, we're going to expound on Chapter 7 just a little bit more and talk about human rights and the International Criminal Court. Now, the nature of international law in our global anarchic system is what you might call still primitive, but evolving, and there might even be some questions as to whether or not it's evolving, because sometimes it may seem like we're kind of retracting from an international system of law. But the fact remains is that we do not have a formal global rulemaking legislative process. We don't have a world president or a global Congress. We have an anarchic system of sovereign states who have the freedom to do what they want to do within their borders and report to no higher authority. So what we have is been evolving from custom or explicit agreements. And since there's no authority to judge violations of one state against another state or to punish the violators, what states have been increasingly relying on over time is various measures of self-help, such as reciprocity, where states treat other states like they would want to be treated, or if there is a collective agreement that somebody's violating, then we might treat that state as we would want to treat someone who's not obeying by the rules. And that's so collective action is another way that states try to come together and enact some form of international justice. And then the concept of converging international norms, whether it's environmental protections or human rights, things like that, peace, those international norms with increasing interaction, interdependence, and empathy and awareness, those might start converging to where states would start agreeing on this is the way that we should be doing this. Now, as far as how international law has evolved over the centuries, back in the 17th century, the Dutch had quite a bit of influence at that time, since they had one of the biggest naval powers at that time. So they were writing a lot of the international laws. We've also talked about the Treaty of Westphalia, which literally established the concept of sovereignty, but it also had a section in there that if states wanted to maintain their credibility as sovereign states, well, then treaties needed to be observed. If you make a treaty with another state, you need to hold up your end of the bargain to maintain your credibility as a state. And then we see that environmental resources have been a pretty good source of environment or international law, particularly dealing with the environment. And the Law of Nations in the mid-1700s was talking about how each state had sovereignty over their rivers, but the quality of that river, the quality of that water needs to remain common. So if you are a downstream state, it is your right to have that river come to your state with just the same amount of quality and quantity that was coming into the state above you. As we get into the 20th century, the League of Nations, which we've talked about a couple of times, the United States did not get involved in that, and it fell apart with the onset of World War II. But as we see, this was the first major modern attempt at establishing a court. So they established what was called the Permanent Court of International Justice, which created this dispute settlement mechanism, but obviously did not hold. And then with World War II, we've already talked about how the United Nations in the modern era of global cooperation was formed in the aftermath of World War II, and we see the United Nations Charter established sovereign equality between the states, but also created the International Court of Justice, which we looked at just a little bit earlier as a part of the UN system, but the ICJ operates pretty autonomously. We'll talk about that a little bit more in a minute. Now, as far as the roots to international law that's still evolving as we speak, we can talk about these in somewhat chronological order. Early on, international law was based on ideological or theological themes that God ordained it this way, and it was not very democratic. It was based on religious doctrine or dogma. And as we evolve, particularly as we get through the Enlightenment and look at some of the concepts of liberalism, we see a naturalist philosophy to international law where there are certain rights that are afforded us in nature, that we have a right to live, we have a right to be healthy and have freedom and own property and things like that. What we see, though, is that this was fairly vague, even though we're still evolving at this time. It's still fairly vague, and the emphasis, of course, is on individualism. And then as we get into the modern era, we see that what is called the positivist theory of international law, where societies start to develop their law based on their customs and practices, particularly of what that particular society wants or needs, their concepts of justice. Those are continuously evolving, shifting, adapting, changing, much like norms do, because norms then eventually turn into rules, then eventually turn into laws, things like that. And what we see is that as society changes as to what it may learn or what it wants or needs over time, this could potentially legitimize previously immoral behaviors. So there's been things, for example, as legalizing of drugs, that we've learned more about how to try to alleviate those social costs in society. So things continuously evolve. We also see that when states get together and make these treaties, these could eventually turn into an international law. And obviously, we've already talked about before that states observe these treaties in order to maintain their credibility, their legitimacy as sovereign states. There is consequences for breaking your commitments. We also talked about the UN Charter that is fairly broad and far-reaching in order to try to get as many states into that fold as possible. And we do see that if you are a state in the world, well, you are also a member of the UN. So despite the fact that states can't get along on everything, we also see that in the aftermath of wars, we continually try to come up with rules of behavior, laws of war, such as the Geneva Conventions on what is the proper conduct in a war. Now, of course, the problem with that is that if you are a sovereign state, yes, you may be obliged to obey these laws of war, but if you are not, such as a terrorist group, it doesn't really make any difference. Now, custom is another thing that evolves over time through repeated practices that become accepted and then become somewhat codified. Common law is an example of that. What we see is that as it becomes repeated and becomes accepted, then it has gone through some sort of process of consent that this society is okay with this rather than a divine doctrine or some natural right. So this is kind of in line with the positivist evolution of law. Or more sources of law, general principles, of course, that we agree on. There's several human universals that all societies tend to agree on, that you don't steal from people or kill people, and those then translate to international behavior. And then sovereignty, of course, is probably the main hard and fast rule that all states will tend to comply with, that I'm a state, I'll take care of my business. And the violation of somebody's sovereignty is a fairly universal principle as well. We also see that As courts are given more legitimacy and jurisdiction, they make rulings, and these rulings set precedents, or some case within a system it would be called case law, that all the other lower courts would have to comply with that ruling. And so that could also evolve as a source of international law. And we do know that, particularly within Supreme Courts in democratic states, the concept of judicial review, where the high court can strike down a law or strike down an executive order as unconstitutional. And so, therefore, all the other courts in the land have to comply with that ruling. Another type of or potential source of law are the representative assemblies. The General Assembly in the UN is probably the best example that we talked about, these resolutions that are passed or these conventions that are created that provide a genesis for international law. Once that convention is formed and that treaty is signed and all the other states agree with it, then the states take that back and ratify that with their own congresses, and therefore that international law becomes law of that country. So therefore everybody would comply with that. Now, one of the biggest problems with international law is how do you enforce it? Because there's no global police force, there's no global or world district attorney that's going to bring charges against a state. So what we've already talked about before is this concept of reciprocity, to where states treat each other like they would want to be treated, or the idea of collective action, that states get together and decide what is the right way to go, and then they will potentially bring reprisals against the states that are not doing what everybody else wants to do. And we'll talk a little bit more about sanctions later on, but sanctions are probably the most common go-to for punishing violators, that gets their attention, hits them in the pocketbook, hits them where it hurts. So we can use embargoes, where we would not buy their products, we would stop trading with them, we would not invest in them, we might even freeze their assets. There's lots of things that states can do to put sanctions on other states, and they are not always effective. And we'll talk about the reasons why they are effective or not effective later on when we look at the economics of the international system. We're also, through evolving norms, we're trying to create expectations of what is appropriate behavior, what is legal, what is illegal. Through that, then we can establish workable rules that all the states are okay with. And so this is why it is difficult to evolve, is because the states actually have to agree on these things in order to enforce them. As we've already talked about, the more powerful states are going to have a little bit more say on that. So it does depend on national power as far as how it could get other states to comply with international law, or if they are powerful enough to where they do not want to adhere to international law. The United States has been accused of that on both sides, of kind of taking international law into its own hands because it's very powerful, or on the other hand, of ignoring international law because we're powerful. Those are some of the biggest difficulties of enforcing international law. Obviously, with collective response and collective agreement, everybody has to be, or at least a majority, if that's what we agree on, which is tough to agree on as well. If not all states are involved or don't care about it, it's not in their self-interest, then that makes it even more difficult. And then, of course, we know that the major powers have disproportionate amount of influence on these agreements. We've already talked about the UN Security Council, that if only one of those 5 permanent members vetoes a resolution, then it won't get passed. Now, what we see is that international law has been more effective in things that are not as high a priority. I've already mentioned how environmental resources, rivers, oceans, seas, air, water, those things have been fairly more readily delegated to international law, where states will agree to let an international court decide on some of these issues that are of lower importance, you might say. That's why we call it more effective in low politics, things like trade agreements, environment, even human rights, things such of that nature. But when it comes to your own domestic economy or your own security, states are typically not as willing to give that out to international law. Most prominently the United States, which is powerful enough not to want to be under the influence of international law. Another part of the difficulty with enforcement is that because we have a system of sovereign states, the states actually have to agree to have that jurisdiction. It's voluntary compliance for the most part. We'll look at some of these numbers here in a minute, but sovereignty obviously remains a barrier that if it's up to you and you don't have to report to any higher authority, then you may not want to be under that jurisdiction. And particularly with cases such as the International Court of Justice that we've already talked about, states actually have to submit a dispute to that court and then agree to abide by the decision that that court makes. And that's a pretty big step for states to make in a system of sovereign states, to where we're going to agree to let this international court decide this dispute between the two states. So it's a matter of willingness. The powers that may not want international law, particularly I'm talking about the major powers here, such as the United States, if we comply with international law, then that's consenting that it will override our own Constitution. And we're not really too crazy about doing that, much the same as why we do not ratify too many treaties anymore, because if we ratify a treaty, then that we have to comply with that law. And we might even have to change some of our own domestic laws in order to comply with that. So it's the same concept here. Superpowers such as the United States might not want to do that, particularly if it might require changing our own domestic laws, not really even public opinion, not very willing to do that. We also have talked about this once before already, that states such as the United States might not want their citizens that are abroad, and we've got lots of diplomats and lots of soldiers abroad all over the world, and we would not want them to be subject to an international court. We would want to maintain control of that. Now, again, I'm talking from the perspective of a superpower to try to explain why this international system of law is so difficult to form, because states like the United States would rather take care of that themselves than delegate that or put themselves in a position of having to comply with an international court's decision. Now, looking at the ICJ, the International Court of Justice, we have to keep in mind that this particular court only applies to states, one state having a dispute against another state, such as Australia having a dispute against Japan or something like that. There are 15 judges on the International Court of Justice, each with a 9-year term. They have overlapping terms. And according to the charter, each member of the permanent 5 members always has to have one judge on that court, which is a little ironic because none of the permanent 5 members are actually part of the International Court of Justice system. So that is a little unusual, but the judges that are put there are very capable of being objective in their rulings. It's just that the states that they come from are not members of the system. And this is what is called the optional clause, that you can decide to be a member of this system or not. And as we see, about 2/3 of states in the world have not agreed to the International Court of Justice jurisdiction. So that gives you a good indication right there of how difficult it is for this international legal system to evolve. And they typically are dealing with issues of secondary importance, not necessarily matters of national security or domestic economy, looking at mostly commercial disputes or perhaps even a border dispute. Here's an example of one that was just resolved just last year, where Bolivia had brought a case against Chile, to where over 150 years ago or so, during a conflict, Chile had gathered this territory right here, and therefore it resulted in Bolivia being landlocked, and it's been a sore spot with Bolivia for a long time. And then about 5-6 years or so ago, Bolivia actually brought a case against Chile to the International Court of Justice to try to get Chile to negotiate on this territory here. And the International Court of Justice ruled against Bolivia, ruled that Chile did not have an obligation to negotiate over this territory for reasons of sovereignty and the fact that it's been part of Chile's territory for over 150 years. So there's several reasons as to why they ruled against Bolivia on that. But that's just an example of a case that would be brought to the International Court of Justice. Here's the actual participants. So as you can see, the majority of the world has not submitted to ICJ jurisdiction. So most of South America, most of Africa, almost all of Asia. And we see that only about 1/3 of the states in the world accept ISJ jurisdiction, with reservations or not. But the United States, as you can see, is somewhat unique because they are the only state that is actually withdrawn from acceptance of compulsory ICJ jurisdiction. So we'll look at a little bit of that history in a moment. So as you can see, this evolving system is evolving pretty slow when about 2/3 of the world's states are not participating in the International Court of Justice jurisdiction. So the effectiveness of the International Court of Justice is subject to this lack of enforcement, because even if it does make a ruling, the states have to comply with that ruling. If they don't, there's really no global police force that's going to come in there and say, sorry, you need to comply with that ruling. And the jurisdictional limits are the fact that most states, it's an optional clause. Most states opt out of being a part of that system. The United States has had a checkered history with the ICJ. In 1984, it actually ruled against the United States with respect to United States involvement in Nicaragua. This is when we were supporting the Contra rebels against the socialist-leaning Sandinista government there, and the ICJ ruled against us, and as a result, the United States withdrew from the optional clause. Mexico, for example, brought a case against the United States in 2003, post 9/11. The ICJ ruled against the United States again, that said that the 51 Mexican nationals had not been given access to consular officials, and the United States had already withdrawn from ICJ jurisdiction. But what the United States also did at that time is that they withdrew from the 1963 Vienna Convention's optional protocol, which required allowing nationals to be given access to their consulate. So as you can see, United States, particularly in post 9/11, really did not want to be hindered or hampered by international courts or international agreements. We wanted to kind of unilaterally take the lead in this war on terror. So this is just another consequence of that. Another option is to use the national courts to reach out further in international systems. And we've seen some examples of this over time. For example, the U.S. Supreme Court ruled against Argentina that had defaulted on its debt a couple of decades ago and still owed some people a lot of money that had not accepted a bankruptcy agreement in that particular case. So that is where the people that live in that system may feel a little bit more reassured that if it's enforceable by the state's legal system, then we might be able to get some action on it. Now, whether or not the United States is going to be able to enforce Argentina to do that, that's another big question. But we do see that individuals and companies can pursue complaints and potentially get compensated if the national court rules in their favor. We also have an organization in the UN called UNCTAD, which allows corporations to bring claims against states or vice versa, where states can bring claims against corporations where an agreement fell apart or whatever, or the state did not hold up its end of the bargain, or the corporation did not do what it was promising to do in that state, and then it goes through an arbitration board. That was on the earlier org chart that we saw. Now, we also have seen other examples where the Belgian courts were given jurisdiction over the Geneva Convention. So if there are war crime type violations that are dealing with Geneva Conventions, Belgian courts have been given jurisdiction over that. So those are some other options. We know that the U.S. Supreme Court has attempted to extend its state sovereignty out a little bit more, particularly with extradition and immigration laws, to where the rulings in our system do have an effect on other countries as far as what they are obliged to do with fugitives or with respect to how immigrants can come into our country. And here's another example where the U.S. Justice Department charged FIFA, the soccer organization, with racketeering, fraud, soliciting bribes, because FIFA had been using the U.S. banking system and U.S. wire facilities to distribute their payments or to launder money. So even though it was an international organization, the United States had some jurisdiction over this because some of the schemes were actually planned in the United States. So these are some examples of how more powerful states' national courts could potentially reach out and do some international justice. Again, if some of the proceeds were through U.S. dollars, then tax evasion was another thing that the U.S. Justice Department could go after an international entity. Just to wrap up here on the laws of diplomacy, because we are ongoing diplomacy all the time with other states. And so, therefore, there are certain things that are recognized. Embassies in each country have what is called diplomatic recognition, to where they can operate almost sovereignly in their building, so to speak. So the host country's laws cannot be enforced within the embassy without consent. So that's why you probably get a lot of spy versus spy drama there of what might be happening within an embassy, because the host country really cannot get involved in what's going on within that. But obviously, if they're doing something illegal, it could potentially come back on them. But what we have here is the concept of diplomatic immunity. To a certain extent, diplomats could be shielded from arrest because they are, again, part of another sovereign territory, so there has to be a little bit more protocols that are complied with there. And diplomatic pouches, as they're called, can't be seized or searched. Now, we also see that the embassies in foreign countries could be targets subject to terrorist attacks, kind of as a symbol, perhaps, or they are an easier target sitting out there in another country. And so Al Qaeda had planted bombs in the U.S. embassies in Kenya and Tanzania in 1998. That was those are two of the first acts that Al Qaeda had done that put them kind of to world's attention. And then the Libya bombing in 2012. So these are just some examples. Now, chapter 7 has got a lot of stuff in it, and we'll be talking a little bit more in the next lecture on human rights and the International Criminal Court.